the details of why. It just doesn't apply, in my opinion, to the states at all. I don't know that whether they'll rule it jurisdictional or not, but it only applies to individuals, and I think the states have standing on their own on the individual mandate. Now, on the merits of the mandate, it is probably the simplest of all the arguments. It is got the most attention. It's the reason I filed a lawsuit. But it's the simplest of all the arguments. The simple fact of the matter is that, I can repeat this one time because everybody's heard it many times from me and others. The mandate in here, the essential minimum coverage language, requires you, if you don't have an insurance coverage somewhere else, to buy an insurance policy or be covered by Medicaid if you're not able to afford it, or pay a penalty. And it's that compulsion, that using of the Commerce Clause. There once was an argument that this was a tax itself, the mandate. And I don't think that the Justice Department any longer really focuses on that. It's really all about the Commerce Clause. And the question is, how far does the Commerce Clause go? How broad can it be? What did the Founding Fathers intend? And it is a powers question. As Lee put it so well in that first op-ed piece, there is no power under the Constitution to do what has been done by this law, by the Affordable Care Act, with regard to the individual mandate. The Commerce Clause is not inelastic. A lot of people for a long time after the 1930s and 40s decisions thought it was. Very clearly the Supreme Court has set forth that it doesn't find it that way, that there are limits. And if there ever is going to be a limit in this area, it certainly should be here. And the crux of the argument is real straightforward. If you are looking at this from the standpoint of how the Constitution reads, it reads that Congress has the power, the federal government has the power to regulate interstate commerce. So we're not going to debate whether it's interstate commerce or not, but we're debating regulating it. This is not regulating interstate commerce. This is all about compelling somebody to engage in commerce. And there's a big difference. And they want to argue on the other side all these ways over here in the weeds about how this is necessary and proper to the regular. But, it's just a way to try to get around it. And if you really look at this, it's a puny excuse for what they're doing. But obviously some people buy into that, people who want to buy into it principally. I don't challenge their honor and their integrity and their analysis or their whatever. There are people, I'm sure, who believe and still want to say that the Interstate Commerce Clause, after the interpretations that came along in 50 years ago, 60 years ago, absolutely anything comes under that. Congress can do anything. But that is not what the court said in recent decisions, and I don't believe that's what they're going to say after the oral arguments in their decision in June about the individual mandate. The other issue that relates to the mandate is severability. Now, I'm going to come to the last one a little bit, Medicaid, and I'm not going to dwell on severability. The severability one is a little more complicated in some ways than the issue with regard to the individual mandate, only because it carries you down lots more rabbit holes. But the basic premise of the of the severability issue is what was the intent of Congress? Would they have passed this law? Would they have passed these provisions if the individual mandate's rule unconstitutional without the individual mandate being there? If they knew that couldn't be there to pay for it, would they have had coverage for pre-existing conditions? Would they have had the end of the rating system, which means that insurance companies no longer can base their premiums on risk that's involved, sorting out who's more at risk than others, and making insurance in the healthcare world really not insurance like we know it at all. Hadn't been that way for a long time, but really going over there and saying everybody's covered. Now, the reality is I don't think anybody logically would say that they would have. And if you look at the whole totality of this law and then we'll begin to look at the Medicaid provisions, which I'm about to briefly review, it seems to me the fabric is so tightly woven that Judge Vincent was right to say, I can't go in and pull out which ones. Are there 16 or there 20 or whatever? Justice Department wants you to believe that only 2 would have to fall, the pre-existing conditions and the ones dealing with the rating, the risk issue. But there are many other things that are intertwined here. It's incredible how it's intertwined and how you sort all that out from the exchanges, the cost, and all of that again this morning that I'm not going into this talk. But that makes the severability issue more interesting because there will be debate over not only whether the two provisions I just mentioned should be severed if the individual mandate falls, because some courts have ruled, of course, that isn't to be severed either. But whether as Judge Vincent said, the individual mandate is the center, the hub of this wheel, and all of this other the spokes, and when you pull the center out, the tire of the wheel collapses. And I think it's the latter, and that's what we want to see the court do: take the whole bill down and remove it. I think there are a lot of scholars who don't think they will take it all down. They'll only take parts of it down, and then the debate is on what parts. Now, Medicaid. That's one that everybody says the sleeper. Well, I'm going to tell you, when our team researched this, it wasn't in Lee's article, his original op-ed, we thought this was very important. It was important strategically for us for a whole host of reasons. It was important because the states spend this enormous amount of money. And there's a court decision in dicta only that says, using the spending powers of Congress, you can only go so far in compelling states to do things. After that, you are commandeering assets. The word coercion and commandeering are not the same, and they're going to argue the fine points of that and say the Supreme Court's never ruled that the federal government has passed a constitutional point of no return, done something unconstitutional in coercing a state, attaching something to a spending bill. I can remember when I was in Congress and we passed a highway bill one year, and in that bill, Mothers Against Drunk Driving got a provision put in there that said that states, in order to get their highway dollars, had to pass a law that raised the drinking age to 21. And that's constitutional, or it's been ruled that way. But the question is, how far can you go? No question the government can do something. But the courts say, hey, there's some point beyond which you're violating the 10th Amendment. You're violating the sovereignty of the state. You're commandeering. And that's what this whole argument's about, is how big this is. In fact, that's what the Dole case talks about, how big it is. If it's big enough, if there's enough money involved, if there's enough whatever involved, the states really don't have a choice. You are forcing them into these rabbit holes. So let me give you the illustration in our brief that is as best I think you can do to gain the scope of this. And just use Florida as the example, my state. 2009, $110 billion in taxes were taken by the federal government from the citizens of Florida, collected in 2009. The state of Florida collected $32 billion that year in taxes to run the state government. Of the $110 billion, about 10%, $10 billion or so, came back to the state of Florida to assist with Medicaid. The state of Florida pays about 40 some odd percent of the Medicaid cost under the cooperative agreement that goes way back to the beginning of the Medicaid program. The cooperative agreement having been stretched many times by the federal government in between, but nothing like the Affordable Care Act does. So now one says, okay, the real issue here, the federal government would argue, is the states can withdraw. You don't have to take this Medicaid program. You just get on your horse and ride out of town and say, we're not going to participate anymore. That's not going to happen. What happens to all the people in our state? What happens to all the money that's gone elsewhere to be used in tax dollars to other states? How do we make up for what would amount to our share of this, or the federal government share, I should say, of the Medicaid program? If we want to do this on our own, it would be about 30% of our tax increase that you'd have to do in the state of Florida to do that. Or you'd have to give up schools, or, I mean, it's just, you can start multiplying this, and I'm again not going to go in every bit of the weeds because there are lots of arguments and lots of examples, lots of illustrations, but this is just enormous. 40% of all federal grant spending to the states are based from Medicaid. It's a huge number. It's billions of dollars of money every year. And it's a very serious matter, the increase of the actual burden that's in this law on top of what already exists. And I just told you about what already exists today, not what is added by the Affordable Care Act. And what's added by the Affordable Care Act is somewhat hidden. The 11th Circuit said, well, we're not going to go along with this after listening to a lot of arguments about it. We don't think the Medicaid provisions violate the 10th Amendment because the amount of money that the states have to put out isn't that great. It isn't that great for a short period of time, if you're looking at pure money, for newly eligible Medicaid recipients. And there are a lot of newly eligible. I mean, that's a whole argument. A lot of time may be consumed on defining all the scope of what people are out there. And the fact that at the beginning of this program, states had a lot of discretion. There were very few people now we've got this enormous amount of money that is being spent in additional, and the states have no way, by the way, of changing the things they used to have discretion for eligibility or cutting corners and cost or whatever under this act. And on top of all of that, it's a big burden. But let me get back to this one point, and that is the federal government does pick up a high percentage, most of the additional cost initially for several years of the newly eligible Medicaid recipients. But with the individual mandate in the bill, the estimate is that about 7 to 10 million people who currently are eligible for Medicaid, who have not previously chosen to join the Medicaid system, will come aboard and will become beneficiaries and sign up. And there's nothing in the law that alleviates the state's burdens for that. And then there's a provision, which is a lot of money, and then there's a provision, additional money, and then there's a provision that says that the states will be required in the future to pay, or assure, I guess is the right way of putting it, to assure that there are enough doctors and hospital beds and nurses and other providers to take care of all these Medicaid eligible people. Imagine the litigation. Judicial wants to put over that. Just to finding, they'll never be satisfied of what the ruling is. Plus there's huge costs. And then there are other hidden things in there as well that I don't think that our team has even raised, probably not wanting to get too far into the weeds and confuse the court. But there, and I'd be glad to do that during question and answers. There are other additional things in the Medicaid area. It's very intertwined, very vicious. What happens? States can't afford it. We cannot afford it. And not only can we not afford it, it is the greatest usurpation of federal, state sovereignty by the federal government in this free country. The individual mandate is about individuals and the states, and it's a violation of the Constitution, and it goes beyond the powers granted in the Interstate Commerce Clause, and it makes the Interstate Commerce Clause become, inelastic. I mean, it makes it way beyond what the founding fathers want. But over here, if you want to take the 10th Amendment, there's never been a time when the federal government ever did anything this big. The states can't get out from under this. There's no way they can give up the money in here and walk away from this and not do this. And they're being, the whole thing was designed so that the Congress knew they couldn't do that. So then they're going to require them to do all these other things. I think it's a very good opportunity for the Supreme Court to draw a line and delineate exactly where and how far the court can go, the Congress can go with regard to this. Well, that's a potpourri, as Paul Harvey would have said. Maybe a little longer than I wanted to do. I probably extended it beyond 7 minutes. But thank you very much. I look forward to your questions, and we're going to win, I think.
No matter how the Medicaid fight, if the Medicaid fight does not turn out the way you hope, it sounds to me like there's a fiscal time bomb here, and that we're talking about the debt crisis in Washington. They intend to take the states out with them.
That's right.
We'll all go down the tubes there. Unbelievable. Well, as Attorney General McCollum implied, Lee Casey, with his partner, quite literally over at Baker Hostetler, have done great work in alerting the American people and public policy leaders about the concerns about Obamacare and the individual mandate. Because frankly, prior to your alerting folks to this, and obviously it's been a little bit in the public domain, but their op-eds, there's nothing better than the Rifkin-Casey op-eds in terms of alerting people in an accessible way about issues related to law and public policy. The individual mandate was always talked about in terms about whether it was a practical issue or not. And President Obama, when he opposed the individual mandate running against Hillary Clinton, didn't oppose it on constitutional grounds. He opposed it on practical grounds. And our next guest, Lee Casey, who is over, as I said, at Baker Hostetler, had previously been at the Justice Department, helping the government figure out what stances to take on core constitutional issues and other important areas of law, has developed quite a following through his and his partners' op-eds in the Wall Street Journal, and the Washington Post, and elsewhere. So he's a leading public intellectual in areas of law. So we're lucky to have him here, and he's a real leader on this issue. And I turn it over to Lee Casey.
Well, thank you very much for those kind words. And also I wanted to, of course, thank Betsy, who has been a leader in this area and against these constant efforts to create some sort of compulsory national health scheme for 20 years or more. And of course, Bill, who it was an honor, of course, to serve as his partner in the practice of law. And he did us the honor, David, myself, and our law firm, of hiring us as outside counsel to the lawsuit. And it's important to know that if it wasn't for him, we very likely would not be here talking about the Supreme Court argument upcoming, certainly not with the issues framed as they are. He put together 19 states plus Florida to file that complaint. You have no idea what that means. That means convincing 19 other state attorneys general to join him. 6 were added later to give more than half of the sovereign states of this union. The Supreme Court could not take this case. I think it was, once that happened, it was unimaginable that the court would not consider the case. But keeping that group together, obviously it's very much like herding cats, but not just cats, very large cats, and each of those cats comes with a staff of other cats, all of whom have law degrees. And so it was no small achievement. But let me very briefly talk about some of the issues that the court is going to address here next week. First and foremost, and I think there's no doubt about it, this is the most important case about federal-state relationships, power under the Constitution in a generation. The core issue is whether the federal government, using the Commerce Clause, can exercise a type of power, which we call a police power, that the Supreme Court certainly, and I think both history and text of the Constitution also supports, has always said was reserved to the states. The federal government has no general police power. What is a police power? Basically, the way the Supreme Court described it in a leading case is it's the authority to make law pretty much on anything affecting anybody within your jurisdiction, so long as you follow individual limits, liberties, either from the federal constitution or the state constitution. But it's a general power just to do what the legislature feels is in the public good. The framers of our Constitution denied the federal government that power. They established a federal government of limited and enumerated powers. Therefore, if the states, for example, want to require you to have health insurance, if the states want to require you, as in the case I just alluded to, get a smallpox vaccine, they can do that using their police power. It's simply a public health and welfare measure, and because you happen to be within their jurisdiction, they can tell you have to do this, or there can be penalties. The federal government can't do that. If the federal government wants to achieve the same result, they have to look at the list of enumerated powers in the Constitution, be it the power to tax and spend, to regulate foreign and interstate commerce, or the other powers, and see how they might go about achieving the same result. They may be able to achieve the same result, but they can't just dictate it or legislate it in the way the states can. And of course, over the years, the Commerce Clause has become the basis of clearly the majority of federal regulation that we live with today. The Supreme Court has interpreted it very broadly. It probably was meant, at least at some level by the framers, to be a broad grant of power because they did want it. Indeed, the Constitutional Convention was called because the states were regulating commerce among themselves and erecting trade barriers, one like small European countries, and it was a serious problem. But the court has always recognized that there are limits to that power, and the fundamental limit, frankly, is it can't turn into a police power. It can't wipe away the entire constitutional balance and structure and allow the federal government simply to regulate people because they're here and because being here, they have some impact on the economy. Everybody has an impact on the economy. The fact that we're here has an impact on the economy. We're not out buying hot dogs on the street or doing something else. And if that is enough, then Congress can regulate everything. It has that police power. And I think that is, frankly, what the court will rule. I do believe that the court will strike down the individual mandate for a number of reasons, but that at the core. And, you know, it's interesting. As Bill suggested, it is unprecedented. Congress has never tried to do this before. And if you go back and look, as I've done, to try to find an example, either in our history or in our history before independence, in the actions of the British Parliament, you are hard-pressed. I found no instance in which either Congress or Parliament required that you enter a market and buy something, simply because you happen to be subject to their jurisdiction. In the late 18th century, the closest thing I found was, ironically enough, in France, in the old regime in France, and of course the framers of our Constitution did consider that a despotism. God knows it was a gentle despotism compared to what we have seen since, but nonetheless, that was their view. And there were two fundamental taxes in old regime France. One was basically a head tax, but the real moneymaker was a tax on salt. Now, they taxed salt because you need it both to survive, but most importantly, you need it to preserve food. It was the only preservative they had. But that wasn't good enough. You actually had to buy a certain amount of salt every single year to comply with this law. So they could tax you, of course. And I mean, I think it's very interesting that the only real example of the type of regulation that we're dealing with Obamacare comes from a regime that the framers of our Constitution thought the very model of a despotism. In terms of the arguments that we're likely to see, I won't get too much into the details because I know you want to obviously get to the question and answer period. I will say, with respect to the leading Commerce Clause case that everyone refers to as supporting the law, that is Gonzalez versus Raich, the most recent of those cases. And in that case, the court upheld regulation under the Controlled Substances Act of homegrown marijuana. California had passed a law that allowed people to grow a certain amount for medical uses. And the argument was made that, well, this is all local, and California has approved it, so it's lawful, and therefore it is beyond the commerce power. The court rejected that and said, well, the fact is, as in the previous case about wheat in the 1940s, Wickard against Filburn, that the impact of those local use of marijuana was sufficient. But I think the important thing to realize about that case is that in that case, Congress was regulating a thing, a product. It was regulating a substance. It wasn't regulating people. If you avoid all of those substances, the Controlled Substances Act really has nothing to say to you. However, if you interact with one of those controlled substances, it has a great deal to say to you. My father, a few years ago, during his final illness, we were given a small bottle of liquid morphine. You have never seen so many frightening warnings with actual citations to federal statutes on that bottle, what you can do with it. When you picked that bottle up, you were subject to all of that, and there were very serious criminal penalties for not complying. But when you put the bottle back down and walk away, you're no longer subject to it. I mean, it has nothing to say to you until you interact with one of those substances. That is not what Obamacare does. Obamacare applies to you regardless. You cannot escape it unless you flee the jurisdiction, unless you leave the country. And that is the quintessential exercise of a police power. I think Bill is absolutely right to raise the Medicaid issue. As he suggested, the courts below ruled against us on that. I think if you read the opinions, what they were saying is this is just above our pay grade. They acknowledged the Supreme Court precedent in this area. They said, however, that there is no case in which the court has actually struck down a federal law on this basis, and therefore we will not